Bryan Kohberger wants to delay his case following a massive leak of evidence detailing the state's case, as Judge Hippler holds a sealed hearing to meet with the attorneys and the attorney for Keely Gonsalves' family about the role of victims. I look at what all of it means for the case.
Welcome to the Deep Dive. Today we're digging into, well, a really big development in the Bryan Kohberger case. His defense team, they're now formally asking to delay the trial. It's currently set for August.
Yeah, and that's a huge move. It's way more than just saying, oh, we need a bit more time. This request, it's all laid out in their latest filing and what was discussed in court. It really highlights some, fundamental challenges they're up against.
Especially being a capital case.
Exactly. Yeah. Plus, it throws this massive spotlight on the whole issue of leaked evidence. That's become a major factor.
Right. So our mission today is to take all this information, essentially analysis based right on those legal docs and court discussions, and really unpack why. Why does the defense feel this August date is just impossible? What are the specific hurdles? And, maybe crucially, what are the potential legal impacts of this alleged evidence leak?
Yeah, it's about understanding the sheer pressure on a defense team. They're basically in a race against the clock, the client's life is on the line, and then you have these outside forces, like the media attention, which seems to be fueled by leaks. So we're going to explore their main arguments for why they absolutely need more time.
Okay, let's get into it. The defense, led by Ann Taylor, she's pretty clear. August is, and I quote, too soon for many, many reasons. So what's the absolute core reason they're pushing back?
Well, at the heart of it, it's really just about having enough time to, actually prepare a defense. And in a capital case where the stakes are literally life and death, the defense has this profound obligation to be exhaustive. And Taylor said it plainly. They haven't had time to go through all the evidence, not enough time to prepare what the system calls a proper defense.
And she actually said cutting off that review before they finish would significantly prejudice Mr. Kohberger.
Exactly. That's the legal standard they're pointing to.
And when you say all the evidence, that feels like a bit of an understatement here, doesn't it? What kind of volume are we actually talking about?
Oh, it's staggering. The defense has pointed out they need to read thousands and thousands and thousands of tips, just tips that came into the case.
On top of everything else?
Yes. In addition to all the normal police reports, the discovery the state turns over. They make a point of contrasting their situation with the state's superior investigatory apparatus. You got to think about it. The prosecution, they had months, right? A huge team, basically unlimited resources, building one story from day one.
Yeah.
The defense, with way fewer resources, gets handed this just mountain of information and it's told, okay, now build a competing story and find the evidence for it.
That difference in resources, it does sound pretty stark when you put it like that. So, okay, they need time for the sheer volume. Beyond just sifting through it all, what's another sort of fundamental challenge they mentioned that needs more time?
Well, this gets into the strategic core of any trial, really, especially one that's high profile. Trials are often called, high stakes duels, a battle of competing narratives. The state, they've been pushing their narrative, Kohberger's guilt, for months now.
Right, in the media, in filings.
Everywhere.
Yeah.
And the defense argues they absolutely must counteract the state's narrative with another compelling story. You can't just poke holes, You need to give the jury an alternative explanation.
Okay, so they need to build their own story. And what is that competing story that the defense is starting to sort of hint at or lay out?
Well, based on what counsel has alluded to, it seems to have a couple of angles. One is, well, simple on its face. Bryan Kohberger is innocent. They acknowledge the knife sheath. Yes, it was found there. But they contend it wasn't Kohberger's doing.
Okay.
And they've also put forward this other theory, apparently supported by a defense expert.
Which is?
That there were two killers and neither was Bryan Kohberger. The expert, they claim, even believes this scenario is likely.
Wow. Two killers, neither of them the defendant. That's a powerful counter-narrative for sure. But it also sounds incredibly difficult to build, let alone prove, especially if you're still digging through those thousands and thousands of tips.
Absolutely. And that leads directly into their third main reason for needing the delay.
Which is developing that theory.
Exactly. The challenge of actually presenting an alternate perpetrator theory. The defense highlights that even just making a reasonable doubt case implies a story that someone else did it. Yeah. But here's the legal catch. In Idaho, you can't just throw out names or speculate wildly that someone else did it.
You need proof.
You need supporting evidence. Otherwise, the judge might rule it inadmissible because it just tend to confuse or mislead the jury.
So they've got this two-killer theory, or at least an alternate perpetrator theory. They need evidence, and they're looking in that mountain of tips. How's that search going based on the filing?
It really highlights the difficulty, yeah. The defense did tell the judge they've submitted some info about alternate suspects they've found. But they're saying they need way more time to find and develop actual evidence to back it up.
And Ann Taylor mentioned something specific.
Yeah, she mentioned stumbling upon just one tip that would appear to be an alternate suspect while they were reviewing. Just one.
Out of thousands and thousands.
Yeah, exactly. It tells you how big that haystack is, And, of course, you can bet the prosecution's going to vex strongly. Their stance is clear. One perpetrator, Bryan Kohberger.
Okay, so reason 1, sheer volume of evidence. Reason 2, strategic need for a counter-narrative. Reason 3, the legal challenge of developing that alternate suspect theory with evidence. What's the 4th big reason they need more time, and why is this one particularly critical in this specific case?
Right. This 4th reason is unique to capital cases where the death penalty is on the table. The defense has a constitutional obligation, it's not optional, to conduct an ongoing, exhaustive, and independent investigation. And this investigation has to cover every aspect of the client's character, history, record, and any circumstances of the offense or other factors.
Okay, why? What's the purpose of digging into all that?
It's all for the penalty phase. If the jury finds him guilty, this information provides the basis for arguing for a sentence less than death. Life instead of death. It's commonly called a life history investigation or mitigation investigation.
A life history investigation. What does that actually look like? What does it involve?
Well, the goal is to present a, quote, full picture of Bryan Kohberger beyond just the crime he's accused of. It's about finding potential red flags, maybe, in his past, understanding any psychosocial stressors he experienced, showing how others perceive an individual and his place in the world. It's really crucial for finding the right experts.
Experts who can explain him.
Exactly. Experts who can help tell the client's story to the jury, maybe answer that big jury question. Why? Why might this have happened beyond just, evil intent?
That sounds incredibly deep and incredibly time-consuming.
Oh, absolutely. It often requires a ton of travel, sometimes even international travel, if relatives are overseas. You're interviewing family, childhood teachers, old bosses, neighbors, anyone who knew the client throughout their life. You might need interpreters.
Wow.
And the defense argues quite rightly that if they can't do this investigation properly, adequately, it could be grounds for appeal later.
On what basis?
Ineffective assistance of counsel. If the defense didn't thoroughly investigate mitigation, a death sentence could potentially be overturned on appeal. It's a non-negotiable part of defending a capital case. You have to do it.
Okay, so they need massive amounts of time for the core investigation, building the alternative story, chasing down alternate suspect leads, and this huge mandatory life history investigation because it's a capital case. But like you mentioned earlier, beyond all of that, there was a more recent event, right? Something that seemed to kind of throw fuel on the fire and maybe specifically triggered this delay request now.
Yes, exactly. This is where external factors really crash into the case. A, quote, massive leak of evidence to the Dateline television program. That seems to be a very specific, very recent catalyst for the defense filing this motion when they did.
Dateline, okay. And what kind of information was leaked to this show? Stuff that wasn't public before?
Yeah, the defense filing lists several things that hadn't been in court documents, hadn't been officially disclosed. It includes details about Kohberger's Google searches, specifically searches for pornography, terms like women being asleep or passed out. Also searches about the serial killer Ted Bundy. Selfies reportedly from Kohberger's phone showing him wearing all black and a hood. And evidence he looked at news stories about the Idaho murders and searched for his own name online.
It's definitely information designed to paint a very specific, very negative picture right before a trial. How did the defense react in their filing?
Ann Taylor's reaction, as described in the filing, is basically one of extreme displeasure. She is, quote, not happy at all. The defense argues these leaked materials were prejudicial and unreliable and, crucially, likely inadmissible at the actual trial.
But now potential jurors might have seen them anyway.
Precisely. The defense contends the leak was carefully curated to construct a narrative of guilt, completely outside the courtroom, outside the rules of evidence.
And this leak wasn't the only media concern they raised just now, was it? Something about a book.
That's right. They also point to this book, The Idaho 4 American Tragedy, by James Patterson and Vicki Ward. It's scheduled to come out just 16 days before jury selection was supposed to start.
Timing seems significant there, too.
Very. And the book apparently claims unmatched access. It says it includes interviews with victims' families and, here's the kicker, local law enforcement.
But aren't law enforcement under a gag order?
They absolutely are. A strict non-dissemination order from the judge, which is why it's so problematic. In fact, the judge himself has already said he suspects that order was likely violated by someone current or former members of the prosecution or law enforcement.
So you've got potentially inadmissible, prejudicial evidence leaked and aired on TV just before trial, and a book coming out claiming access to law enforcement sources who shouldn't be talking, also right before trial. The defense was pretty critical of the style of that TV program too, right? Not just the content.
Oh yeah, they went after the style hard. They described the Deneen episode using things like dramatic effects, reenactments, music, emotional interviews. Their argument is this isn't just news reporting, it's, quote, uniquely prejudicial in both tone and content. They called out emotionally manipulative production elements and said it amplified unsupported theories through self-styled expert commentary.
And the timing again.
And the timing. They stressed it aired just weeks before trial, when potential jurors are, in their words, most vulnerable to this kind of influence.
Okay, this whole leak issue feels massive, not just for the media narrative, but for the actual legal process. What happens next with investigating who leaked this stuff?
Well, both the judge and the defense agree. There needs to be an investigation into the source of these leaks. It's essential. The defense filing even hints that, depending on what that investigation finds, just delaying the trial might not be enough. If the violations are serious, it could warrant, quote, remedies more serious than delay.
Like what? What are the potential legal consequences if they can trace this leak back to the state side? Prosecution or law enforcement?
Well, according to the legal analysis we're looking at, if that leak is found to be ascribable to the prosecution or law enforcement, then it becomes really significant constitutionally and statutorily for the defense case. It could potentially be the basis for filing a motion to dismiss the charges entirely, or maybe suppress evidence. They'd use the legal concept of outrageous government conduct.
That sounds serious.
It is.
Yeah.
Defense counsel basically said she owes it to her client to look into it. Not investigating potential government misconduct like this could even be seen as legal malpractice.
Outrageous government conduct.
That sounds like a really high bar to meet, though. Is it hard to actually prove the state or police were directly involved or that they intended the leak?
Oh, it's incredibly difficult. A very high bar, yes. The analysis we saw mentioned the comparison to the Richard Allen case, leak, the Delphi murders case.
Right, where crime scene photos were leaked.
Yeah. In that situation, the leak wasn't ultimately pinned on the state or the DA's office directly. It was tied to someone who mishandled the evidence. Proving direct state involvement or intent is really complex.
So just to be clear, who actually had access to this sensitive discovery material that got leaked? It wasn't just the lawyers, right? No, access was pretty widespread, relatively speaking. Obviously, the defense team itself, the lawyers, paralegals, associates, any experts they hired, then the prosecution team. And remember, that's often a big office. Not just the lead prosecutors, but secretaries, paralegals, social workers, investigators.
A lot of people.
A lot of people. And critically, the different law enforcement agencies who worked with the prosecution on the case. And as we mentioned, Judge Hippler, as reportedly already indicated, he thinks the leak probably came from that stateside, current or former prosecution or law enforcement.
Okay. And if they do find the specific person who leaked it,
yeah,
what happens to them? What are the penalties under Idaho law?
This might be surprising, actually. The direct criminal penalty for the leaker themselves might be relatively minor. It could potentially be just a misdemeanor charge, like obstructing a public officer, violating the judge's order. The maximum penalty might only be like 5 days in jail or a fine, or maybe contempt of court charges.
That doesn't sound like much deterrent.
Probably not. And the expert analysis notes, it's pretty unlikely prosecuting authorities would file criminal charges against their own people, especially for just a misdemeanor. However, the leaker's career, that's almost certainly over if they're identified.
Right, professional consequences.
Huge ones. But, even if finding the leaker doesn't lead to the whole case being dismissed, identifying them is still really important for the defense.
Why is that?
Because if that person, whoever leaked it, ends up testifying at the trial about anything, the defense team would absolutely be allowed to cross-examine them about the leak. Ask them about it right there on the stand. It's considered fair game. It goes to their credibility.
Okay. So the leak investigation has potentially serious legal angles, even if dismissal is a long shot. But couldn't some of the, the damage or prejudice from all this media attention, including the leak, couldn't that just be handled during jury selection, during voir dire? Isn't that what it's for?
That is the standard legal tool, yes. And the expert analysis does suggest that really thorough questioning of potential jurors, asking them specifically what they've seen or heard, asking about the Dateline episode that could potentially cure the prejudice.
So the leak might end up being less impactful.
It might end up being seen, legally speaking, as much to do about nothing if, and it's a big if, they can successfully seat a jury pool that hasn't been significantly tainted by it. The whole goal of jury selection, the fundamental goal, is to make sure Mr. Kohberger gets an untrained, impartial jury. That's the standard.
It makes sense that voir dire is the attempt to fix it. But boy, with this much media and now this leak, it sounds like a massive challenge to find that impartial jury. So let's bring it all together. You've got the immense preparation needed for a capital case, the strategic battle of narratives, the legal hoops for alternate suspect evidence, the exhaustive life history investigation, and now this disruptive, potentially really prejudicial impact of leaks and media. What's the bottom line? What's the prediction? Will the judge actually grant this delay?
Well, the defense's core position, the way Ann Taylor framed it, it's pretty direct. She simply needs more time. She's not ready. And she's emphasizing that denying the request, especially regarding that crucial capital mitigation investigation, risks reversible error later on appeal. That's a powerful argument to make to a judge.
And how does the legal expert you've been referencing view the strength of that argument? Do they think she has a good case for delay?
Yeah, they express quite a bit of sympathy for the defense's position here. They believe Ann Taylor has really valid grounds. These aren't frivolous, made-up reasons. In their view, the judge's hands might actually be somewhat tied to turn her down, given that she's shown good cause and has, quote, feverishly asked for it, especially emphasizing those constitutional duties in a death penalty case.
So are they basically predicting, the delay will be granted?
Yes. The expert seems optimistic about it. The prediction is that Judge Hippler should give her, at a minimum, a brief continuance.
Okay, brief. What does brief really mean in the context of a super complex capital case like this one? Are we talking weeks, months?
It's relative, for sure. But in court terms, brief might mean something like, say, 30 days, maybe 60 days. The expert suggested maybe 90 days.
Okay, so maybe up to 3 months.
Potentially. And the reasoning is interesting. It's not just for the defense to do their investigation. It's also to give the prosecution time to review and maybe rebut whatever the defense finds, especially on that mitigation evidence.
The state needs time to react too.
Exactly. Sometimes defense attorneys will even stipulate to a reasonable continuance for the prosecution for exactly that reason. Give and take. The expert also floated the idea the judge might sort of keep her on a short leash.
Meaning
maybe grant a shorter delay initially, like 30 or 60 days, then have everyone come back to court, check on the progress, and then decide about the full delay she requested. A phased approach.
That makes sense. Manageable chunks. That level of detail on the potential timeline is really helpful. It shows just how intricate these court proceedings get. Before we wrap up, there was one other little piece of related news mentioned in the source material, wasn't there? Something about the victims' families.
Yeah, just briefly mention. The judge apparently held a sealed hearing recently with the lawyer representing the Goncalves family. The topic was about the role of victims and their specific rights under Idaho law, which apparently includes the right to be heard in court proceedings.
But it was sealed, so we don't know the details.
Right. Since the hearing was sealed, what was actually discussed isn't public yet, but the judge might release some kind of summary later on. Still, it's a notable development happening alongside all this.
Definitely significant, even without the specifics yet. Okay, so to kind of circle back for you, the listener, the core challenges driving this whole delay request are just immense, aren't they? You've got the sheer scale of preparing a defense for a capital case under this blinding public spotlight. There's the strategic need to build a compelling counter-narrative basically from scratch against the state's established case. You have the specific legal hurdles for presenting alternate suspect evidence, needing real proof, not just ideas. Then there's that mandatory, incredibly thorough life history investigation for the death penalty aspect. And now, layered on top, the disruptive, potentially really prejudicial impact of these leaks and the intense media storm right as the trial approaches.
Yeah, this request, it really boils down to ensuring the defendant's fundamental constitutional rights, the right to effective legal counsel lawyers who actually have time to do the work, and the right to a fair trial by an impartial jury. Those rights seem clearly under pressure here from just the sheer volume of information, the strategic demands of this kind of case, and these significant external pressures from media and these alleged leaks.
Which really raises a pretty challenging final thought for you to maybe chew on after this, given how absolutely pervasive media coverage and social media are in these huge high-profile cases today, and how easily sensitive, potentially inadmissible information can apparently be leaked or just spread everywhere outside the courtroom. Can courts truly ensure that ideal of an untrained, impartial jury in today's world? Or is that whole concept, the idea of a truly isolated jury pool, just becoming harder and harder, maybe even impossible to achieve in a world where information and potentially misinformation is just everywhere all the time?